The world turns, and with each turn, a change. And each change makes it more complex, unpredictable, enigmatic. The world keeps turning. And from the Pellicer and Heredia practice, we anticipate everything that is going to happen. Brexit, artificial intelligence, new commercial borders, legal tech. The world keeps turning, and it commands the reliance on international lawyers who are capable of interpreting this new reality with integrity, honesty, and transparency, offering answers to so many new questions. Whatever it is, ask us. At Pellicer and Heredia, we know how.
Hello, good afternoon, everyone. Well, thank you very much for joining us today. Today will be the last webinar of 2021. It's amazing how time goes on. We've done a few already, obviously. And today we thought it would be good to end up with, as topics requested by clients, British and Spanish wills, key issues to consider when making a will in Spain, and inheritance tax planning. So important to do all these two things combining together. Endurable power of attorney, and then we're going to talk about mediation, how important to discuss with your family lawyer. We're going to have a funeral director and insurance, and then we'll just carry on with questions and answers. We're going to have 1 hour, and I hope it will be good enough. Last time we couldn't answer to all the questions. I will be grateful if you could start sending your questions already in the panel. There is a chat here. You could send it. And then I'm going to just jump now and introduce to all in the panel, all the speakers. I will start from Spain, and then we will go to the UK. We've got Pedro Heredia, international lawyer. Hello, Pedro. Can you hear me?
Oh, hello, Ignacio. Good afternoon. I can hear you very well.
Very well from Alicante. We have going down South Almeria, Michael Davies, solicitor. Hello, Michael.
Hello, Ignacio. Nice to see you all.
Very good. Thank you. Michael Davies is a specialist as well on inheritance tax. I'm sure he's going to bring us a lot of information about difference between Andalusia, Comunidad Valenciana, etc., etc. I'm going to just introduce you to Jan Coulton. She's an elder mediator. Hello, Jan, from the UK.
Hello, Ignacio. How are you? Thank you for inviting me along. Thank you.
Okay, thank you. Thank you for joining us, Jan.
I'm
sure you will bring a lot of information. And we've got Stuart Hanson, a family mediator as well. I think Stuart is in Costa Blanca. Hello, Stuart.
Hi, Ignacio. Thank you very much for inviting me today as well.
Thank you. Then down south, I think more in the Heredia area, is Rebecca Laurie. She's from Avalon Funeral Plans. Hello, Becky.
Hi, Ignacio. Good afternoon.
Right. Okay. Let's go for it now and start talking about all the ins and outs. I think Pedro was going to start doing we're going to try to concentrate each other on 5 minutes. And then we could start answering the questions, etc., etc. Pedro, if you're happy to start, please go ahead.
Okay, well, just to have some noise here in where I am right now, but hopefully, let's see if you can hear me or listen to me correctly. Obviously, what we are talking about is important on our legal side and our legal point of view. Really, it's important to planify estate planning, not just inheritance, but also during life about a will. It's important to have a will duly prepared in order to be able to, at the end, what is going to end up. It happens to us, and we have some experience on that sometimes what someone who makes would like someone, a beneficiary, to receive assets do not happen because of conflict of law, because of applicable law is not exactly what it was decided by someone who at the end leaves us. So it is important, Ignacio, and just to clarify some points, whenever you are in Spain and you are resident in Spain, it's extremely important to make a will. And we always recommend that. We always recommend to make a will because whenever someone from a different culture or different nationality comes to Spain and do not do anything, the criteria on European law is attract rapidly the applicable law to be the residence law. I mean, this is European law, it's not just a Spanish law. And whenever someone becomes, in this case, resident in Spain, will be in most of the occasions, I mean, I would say in most of the situations, sorry, applicable law, the Spanish law. I mean, this is not just to choose the beneficiaries, which is one of the most important things on a will. Also, there are some other consequences, but focusing on who are the beneficiaries and if they are going to receive or not, in order to be sure, in order to be confident, in order to be have a peace of mind on who is going to receive the assets, is extremely important to make a will. As a Spanish law has some limitations, let's put an example, is 2/3 of the assets goes to the children. I'll put my example, personally my example, I am married and I have 2 children. So those children, my children, will receive 2/3 of my assets. There are some other rules, but in general, this will be the situation. And so I cannot leave everything to my wife. This is a Spanish law. If someone from a different country comes to Spain and lives in Spain as a resident, will have the possibility, will have a faculty to choose whether it's better the national law, the law that holds a passport, or maybe the Spanish law, which is also correct. So it's important to planify what's going to happen and say that expressly. So make a will. Obviously, we always recommend to make a will in Spain whenever it comes, but obviously it's a written express about that. So having said that, Ignacio, is just to say a will, and obviously we will enter during the meeting about the inheritance process. I know Michael is very experienced on all these situations on inheritance tax and wills, obviously, and we will be able to discuss a lot further with this.
Okay, Pedro, thank you very much. Then I'm going to pass over to Michael Davies, who, as you say, he's an expert in this field, and I'm sure he will bring a little bit of light here, or at least his expert advice in this time. Over to you, Michael.
Hello, Ignacio. Okay, I only got 5 minutes, and I'd like to talk about this for the next 2 hours, so I'll try to keep it going. Firstly, my name is Michael Davies. For those that don't know me, our firm is Davies, Abogados, Solicitors and Barristers. We're based in Andalusia, and we are dedicated almost 100% to winding up estates for international clients. So we deal with a lot of inheritance cases over the last 25 years. We do some wills as well, but mainly we deal with the result of what happens when somebody passes away. So the first thing is for people don't need to worry. The business of the inheritance is actually very, very straightforward in Spain. So there are 2 aspects to think about. One is to make sure that the people that you want to receive your estate do actually receive them. And with this, there's a lot of talk on the internet and the things about the obligatory heir system in Spain that makes people very, very worried. But they needn't be worried at all, because it's got a very easy solution. So from that point of view, what happens is that Spanish international norms establish that if you don't make a choice of law when you make your Spanish will, they will apply the law of the last residence. Okay, so if you're a resident in Spain and you don't make a will, it could indeed be a disaster, because it can end up applying Spanish obligatory heirs, which they will do if you haven't made a will with a choice of law. And that would actually mean, as Pedro rightly says, that the kids receive 2/3 of the estate, which could cause a lot of problems, obviously, because the wife can't receive the full estate, etc. So how can that be avoided? Very simple, because the Spanish norm, which has been taken from European law, allows people of other nationalities that are living in Spain to make a will in Spain, choosing their national law to determine how they're allowed to distribute their estate. Okay, this is called Directive 650/2012. Any lawyer that deals with foreigners will know how to put in the clause of choice of law into your will, And with that, you can then go on to leave things however you like, exactly as you would do in the UK. So very important. If you make a will with someone that's done wills before, for English people, you don't worry. He'll automatically tell you to make a choice of law. We'd make the choice of law even if you were a non-resident of Spain, because it avoids the beneficiaries later on having to prove that indeed their dad was in fact a non-resident of Spain, resident in the UK. So just make the choice of law, and then you can do whatever you want. The other aspect of the Spanish inheritance scene is the inheritance tax. This worries many people, but the truth of the matter is that in most regions of Spain now, the levels of inheritance tax for Group 1 and Group 2 beneficiaries, in other words, spouse and descendants, is extremely low in most cases. So, I mean, for example, in Andalusia, the first €1 million is exempt, and after that, you get a 99% deduction. So basically, for a spouse or a direct descendant to inherit in Andalusia, they're going to pay almost no inheritance tax. In Valencia region, you pay a little bit more, but the exemptions are quite generous. I mean, there are some other places like Andalusia, like in Madrid, where you also pay almost close to nothing. So the inheritance tax is not such a big issue. And in fact, as Ignacio, Pedro, as you know, we've lost a big part of our the old way we used to make money, which was we used to do a lot of consultations for high net clients that were trying to decide where in Spain they would retire to based on the different regional inheritance exemptions. So that part of the business has to a great extent disappeared because the inheritance tax levels now are quite low all over Spain, even though there are still some areas that are better than other. Murcia, for example, is a bad region at the moment still. Andalusia is really good. Madrid's very good. The Basque Country is really good. Valencia region is not too bad. Catalonia is not too bad. So there are different regions with slight differences, but in general, the inheritance tax is low for group spouse and descendants. So there's just so much we could talk about, Ignacio, but basically the main thing I think is to remember to make a will in Spain as soon as you have assets over here, because otherwise you will be dealing with a completely foreign system, which will end up not being good for your beneficiaries.
Okay, Michael, thank you very much. I'm going to just pass over to Jan. She's in the UK, and probably she's got a lot of things to say as well. Jan, over to you, please.
Thank you. Where to start in 5 minutes? Yeah. Mediation in a nutshell. A few days isn't enough. Let me go along with what Pedro and Michael have said, endorse the comments about making a will. And yeah, gives you peace of mind and settlement to know it's sorted out and that your loved ones aren't going to have to pick up the pieces in the event of your demise. So mediation can fit into this in many different ways. By talking to families, and it's sometimes called intergenerational mediation, but it's talking to families about how they wish to deal with the future and what they wish to do. And in relation to these types of discussions, we could be talking about planning finances, planning care for later life, but also care in the event of younger people that may suffer from terminal or disabling illnesses and may need some powers of attorney putting in place to deal with different situations once they still have capacity and what might happen when they don't have capacity. It's a really difficult subject, and it's one I would urge everybody to look at and discuss with the families, if indeed they have families, about what will happen in future. Once things start to go wrong or people get ill, it's a little late in the day because you're not at your best to make these decisions, and very often people come to family mediators at that time and elder mediators for later life to have these discussions so that there's some understanding between older people and their children about what the future looks like, how it's going to be dealt with, and particular provision is made for care in later life. And that provision could be for home care actually going into a home, support, how to make a will. Mediators very often signpost to other people, lawyers, other professionals that can give support and help. One of the characteristics of older people mediation is that very often with failing health, it's very difficult to make these decisions and stand back from them. And it's good to be able to talk to an independent third party, such as a mediator, who is specialised in trained in being impartial and being confidential with the usual safeguarding concerns. So the sky's the limit with mediation, basically, about the things that you can talk about and bring to the table and make provision. If it's simple, no relatives and you don't know what to do and who's going to look after my beloved companion pet, or I'm married or I'm unmarried and I'm worried about provision, all these things can be talked about within mediation with a trained professional. So that's just unpacking the tip of the iceberg. And as I say, if the mediator feels that you need independent legal advice, then we would be passing you off to the lawyers to give you that independent advice and to make binding provision for the future according to the particular law that applies to where you're resident or where your property is. Thank you.
Thank you very much. Jan, I'm going to pass over to Stuart. I'm sure he's a family mediator, and he's going to just give us a little bit of his recommendations. Over to you, Stuart.
Thank you very much, Ignacio. I've listened to everybody and it is sound advice, but I think to add that I deal with mainly couples who are separating or divorcing, and some people go on to live new lives following their separation and come to Spain and never make that will, never get that divorce. They're living their separate lives. I've got a case at the moment. They've been separated for 20 years and never had the thought, but now when pensions are coming into play, potential claims on pensions, even lottery wins, if we are going to play the Spanish Christmas lottery, we've got to think about how, when we do, if there's a situation where there is a separation or divorce, making sure the paperwork is done properly. So it's really important to, if you are going through a divorce or separation, to change your will, because a lot of people don't change their will. They may have a will and it stays there forever, and unfortunately, there could cause a lot of family problems afterwards if you haven't updated it. Separation agreements as well for properties and many things, just to make sure that if the inevitable, when it happens, you're making sure you're leaving your money to the right people, really. And I'm thinking again, like Jan said, about your support network. It's a really important thing to think about, especially when you move countries and as you get older, the support network might dwindle, it might get less and less. And you have to think about isolation and about, having those conversations with your family who may be abroad, to discuss what you'd like to see happen, and find out what they would like to, what support they'd like to give you as well. I had a few questions. I don't know if I'm allowed to ask questions at this stage, but one of the thoughts was about where documents are lodged in Spain. I think I have an English will, and I'm about to sort out my Spanish one. And in the UK, you can lodge your will with a solicitor or with a certain organisation. I just wondered, if when I'm dealing with a separating couple or divorcing couple, and they've moved to Spain, one partner has, where do they have to lodge their new will in, with a solicitor, or do they keep it under the bed in a metal box, waiting for somebody to discover it? I just didn't know the answer to that, and I thought it would be helpful.
Michael, would you like to take that one?
Yes, of course. Well, I have to say that in the case of the system of registration of wills, the Spanish system is actually superior to the English system. I am British, by the way, so I'm being honest and truthful, not taking part. But in Spain, a will is not valid unless it's registered in a central register system. So in other words, basically, any solicitor that goes to probate in Spain, the first thing they have to do is write to the central register, and the central register will confirm which is the last will signed in Spain, and then
The
we can
world
only access the
turns,
last
and with
one.
each turn a change.
Oops.
And each change
think
makes
we're
it
having
more
problems here.
complex, unpredictable, enigmatic.
There we go. Sorry, Michael. The system is going crazy.
No problem, no problem. So we can then, the solicitor then can access the last will signed in Spain. In fact, on the certificate, you'll see a list of all the different wills signed with the dates, but you're only by law allowed to access the last one because of data protection. You could access the other ones if there was a court case or something like that. We've accessed them in the past, but only as part of a court case. You only access the last one. Or if there's no will, in other words, in Spain, you can't go to an intestate procedure unless you prove first to the system that there is no will, and you'd have to prove that with the same certificate from the central register, but in which the certificate would say that there's no Spanish will. So it's very simple. In Spain, we don't have the situation where a will suddenly appears out of the drawer. No, because all wills have to be registered. And they're registered by the notary. So the solicitor prepares the will, it gets witnessed in front of the notary. And when the notary in Spain charges you the 60 or 70 euro to witness the will, it also includes the registration in Madrid of that will in the central register. And it works like clockwork, it never fails.
Thank you, Michael, thank you.
Stuart, would you like to do the next question you had, and then we will jump on with Rebecca?
I think that was one of the main ones. Just understanding where you register it, and obviously it's an easy, simple process, and really helpful information for everybody. I guess I think do wills ever expire? I'm guessing that they don't, or they just stay there until the next.
And also in Spain there are less reasons for the will to become invalid. In other words, in the UK, if you get married, change of circumstances, the will becomes invalid, etc. In Spain, it doesn't. So in Spain, bringing back to what you mentioned before about the divorce and people not changing their will, Ignacio and me are experts in this because Ignacio handles lots of divorces, I handle lots of inheritance, and we always make sure that even halfway through the divorce, that they do their will, because otherwise suddenly you could be fighting for 2 years over a divorce, and suddenly, all the money, one of them dies, your client dies, and all their money goes to the wrong person, and all the work is down the tube. So basically you'd always recommend the new will as basically as part of the divorce procedure, and it's even more important in Spain because it doesn't automatically become invalid because of change of circumstance. So I had a case many years ago, and that's why I'm so careful with this, in which we handled for a very wealthy German doctor. She'd inherited a tremendous property from somebody that she'd had a relationship 16 years ago, and he had never changed, a German surgeon, and he never changed his will. So my client was very lucky. She called me one day. She was only a client from that, but not from before. She says, I think I've inherited a property in Spain, and it was 16 years ago, and this gentleman had 2 relationships after her, and she inherited a very large and expensive villa because he never bothered to change his will. So it does happen.
Actually, Michael, we're having here in the panel some questions, and I've got later on to comment certain things I've seen in an article. Well, certain things that they're being published that I would like to discuss it with you. But one question that made me think here, Michael, and I had a case. Actually, I've seen, I don't know if it happens to you, I've seen an English will signed in England, in the UK, and registered at the Madrid registry. So they did sign a will. So let's put it this way.
You use these webinars to get to take all my secrets from me. We do those wills. We do those wills. Exceptionally, what you can do is you can not many people do them this way, but let's say, for example, during the coronavirus, where you've had people that can't come over to Spain, you can actually send a will in 2 columns to be signed in front of a notary in the UK. And if you have the Hague's apostille affixed to it and sent to your office in Alicante or wherever, you can then apply with that will that's been signed in the UK to the central register for them to register it as if it was a Spanish will. You can do that.
So I know it's very messy. I know it took 6 or 7 months. I remember this person saying, and here you have, Michael, a question that says, I think they're referring to, can you register your American will in Spain? Actually, it's easier, Michael, isn't it? To do a will here in Spain for Spanish assets, isn't it?
Yeah. What I was talking about before was, in other words, you, a Spanish solicitor, saying, I'm going to prepare a will as if this person was in Spain, but in 2 columns, like we do the powers of attorney. And I'm going to send it over. And the notary in the UK is going to say, it doesn't make sense. But you say to them, no, there's nothing illegal. You're just saying that you're witnessing the will. So you do it in exactly the same format as if it was in Spain. And then you have the Hague's apostille said over here. No, I'm not talking about taking an English will and asking for it to be registered here, because that's just asking for trouble, because the English will be in an English format. It may mention the word trust. So it's not that technically it's impossible. It would just be foolish to do it. So if you basically, the correct thing is to have one will in each country. And in relation to the assets in that country, and exceptionally, we could do what we've just mentioned before. And if it wasn't something really, absolutely essential, because you've got a client that's dying in a hospital in the UK and it's impossible for them to come over, or coronavirus or something really bad, unless it was for that reason, the best thing is just to make a will in each country.
That's good, Michael. Actually, Michael, I would like later on to discuss with you and Pedro here. It's been published in an article in a newspaper that obviously I did report to the editor. That is not correct. Some people, I don't know if you got in Andalusia, the scaremongering of, if you wrote your Spanish will before the 1st of 2021 and think it still covers your assets in the UK as well, think again. You need a will for Spain and one separate will in the UK. Well, they are sending these messages. I don't know if you've seen it.
Sorry, what was? I missed it. What were they saying?
Yeah, they're saying, Michael, that January 1st, 2021, things change in Spain with regards to wills because of Brexit. And obviously, I'm having these clients.
What were they saying? That it changed in what way?
They say now, I've got it here in front of me, it still covers your asset in the UK as well. So they're saying, if you have a will, let's say you do a worldwide will about all your assets around the world, they're saying because of Brexit, that will not happen anymore, you see? And Brexit doesn't affect here. At the end of the day...
No. The Brexit doesn't have any effect on the wills. Now, there's various things that people sometimes are asking is, one is, can they still make the choice of law now that on the Spanish will after Brexit? It makes no difference, okay?
Probably. I mean, I haven't read that article, obviously, but
and then regarding making a will in Spain to be valid on worldwide assets, it's not bad as a sort of last resort, but it's not the good thing. I mean, we don't recommend people making a will in the UK for worldwide assets and then using that for Spain, but we don't recommend it the other way either. Sometimes someone comes to us and say, well, Michael, I'm not going to go back to the UK. I've really got very little over there. Can we make the one in Spain for worldwide assets? Yes, but later on, it's going to have to be convalidated for the use in the UK with all the normal convalidations, Hague's apostilles, official translations. So it's not really the right way to go. The only small changes that have happened since Brexit are, for example, that with the EU for the last year and a half, for example, death certificates and marriage certificates, birth certificates, marriage certificates, death certificates did not need to have the Hague's apostille affixed to them to be valid in Spain, as long as they were going to be used in front of official registers in Spain. Why? Because a year and a half ago, they decided, or no, 2.5 years ago, they decided all within the EU to share their databases. So you didn't need to check to see whether the signature of a notary in the civil register in the UK, the Spanish registrar could look him up to see whether he was really a registrar over there, and therefore didn't need the Hague's apostille on it. So that has changed since Brexit, because the moment Brexit hit, they don't share their databases anymore. So we're back to using the old Hague's apostilles like we always used anyway. So it's not a big deal. There was a difference at the beginning with the tax implications for the beneficiaries that were non-resident to Spain. and were where they were resident in a third country, in other words, not in an EU country, they weren't protected by the sentence of the European Court of Justice that said that those non-residents were entitled to the regional exemptions. But that now has all gone away on the 7th of July this year. They've updated the laws, and now if, for example, I'm the son of somebody that dies in 𝐸𝐤𝐿𝐼𝐻 and I'm inheriting an asset in 𝐸𝐸𝐿𝐼𝐻, even though I'm a non-resident of 𝐸𝐤𝐿𝐼𝐻, I can still claim the same exemptions as if I was a resident in 𝐸𝐤𝐿𝐼𝐻, just because I was receiving the assets there. So that's been updated because of Brexit and all the amount of English people that would have caused problems for that. So in reality, Brexit hasn't affected anything to do with, from real terms, hasn't affected anything.
Pedro, would you like to add something else to that question about the article?
Obviously, this article that you said has been advert in, I don't know where, in the south of Spain. Obviously, probably, it misunderstands absolutely everything about European law, the criteria about whenever someone is resident in Spain, and the criteria not in just act, in the many acts of European law, the criteria of residency is put on the position of which this is the criteria is going to be taken, and not the nationality. Before this law that was mentioned by Michael, 650-2012, which came into effect in 2015 in August, then it was resident nationality. But now really the criteria is residency. So you are resident, the applicable law is the resident where you are, unless you expressly say that your national law will be included in your inheritance. That's all.
Sorry. So I've just realized, Ignacio, is this what you just mentioned before? Has this got something to do with this question here? It says, I have read that saying that the Spanish will.
I was going to go for that, John.
Okay. That one. Okay. This question here says, I have read that saying that a Spanish will should be administered according to UK law is no longer valid, and we should state that it should be administered according to English, Welsh, Scottish. Okay, that is correct, but that's not correct because of Brexit. It's always been correct. UK inheritance law doesn't exist. You have English law, Scottish law, thing. So when an English person in Spain chooses his national law, he can never choose British law or UK law. He has to choose English law, Scottish law. And that has always been the case. We've seen that mistake happen many times. When it came out, some Spanish solicitors that didn't realize that the laws were different in the UK, they were just sort of saying, I choose British law. I haven't seen this for many times, but at the beginning, there were some people that were making that mistake. In the end, it was no big deal because the notary just asked to prove, this person from, were they from Scotland or were they from England? And that's the law that we apply. So
at the end of the day, Michael, when they refer the notary said, and I remember having this discussion with a notary, they're saying, you're British national law, you're British. So therefore, you choose in British law, but you need to mention whether you're English, Scottish, or whatever. Yeah. But the national law in Spain for the notaries, and I've seen a lot, they say, well, it's British law, but you need to mention or you need to refer whether you're...
On all our wills, we say, I choose my national law, and we just established either English law or Scottish law, or Scottish law is very different from English law as far as inheritance rules. So, it's like if the Scottish law is closer to Spanish law, so it's it wouldn't be very, very helpful. Yeah.
Right. Let's move on. I'm just going to introduce you to Becky. Becky is she is from Avalon, and Becky, I know a lot of people we have in the panel here that the popularity of this type of insurance. If you could just let us know why it's best to have a funeral plan, either with you or with any of the competitors. And yes, over to you, Becky.
Absolutely. Okay, so I'm going to talk to you today about funeral planning here in Spain and explain some of the differences and some of the challenges that most expats face when residing abroad, but also how a funeral plan can help. I'm quite conscious of the fact that I've only got 5 minutes, so I'm going to do a brief presentation for you. And of course, if anybody's got any questions, you can ask me afterwards. But there are lots of reasons why people arrange funeral plans. Today, I've picked out the most 3 important. Obviously, we've got timings there. So unlike the UK, here in Spain and in many European countries, funerals can take place quite quickly, within 24 to 48 hours. This obviously leaves little time to make arrangements and personalise the funeral. But also European funerals tend to be much simpler with less choice than in the UK. And it may not leave enough time for the loved ones. It can put a lot of stress. We've also got the language barrier. Obviously, some of us may be able to speak Spanish, but it's very difficult to understand things properly, and things can be misunderstood if obviously we're in difficult circumstances. At the time, you must contact the Guardia Civil, a doctor, a funeral director, and things may not be as straightforward if the death occurs outside of the home or at the hospital. There's also a body release form that will need to be signed immediately, and obviously this will be presented in Spanish language. And then we've also got the costs and payments. As funerals, the costs of funerals are rising each year. What we should also consider is here, it's very normal for the funeral directors to expect the payment upfront. So again, very differently from back in the UK. The assets can be frozen, making it difficult for family to access savings. The family might need extra time or permission to access those funds that are needed. But of course, as well, any delays may incur more costs, such as mortuary fees here, which are normally charged by the day. We also get asked a lot of questions as to what is a funeral plan. So basically, a funeral plan is all about buying and arranging the key parts of your funeral before the funeral takes place, making it easy for your loved ones and family in the future. But it also allows the person to focus on enjoying their life today without having to worry about the loved ones being left to cover the costs. It's about making your wishes known and getting the type of funeral that you want. And unlike insurances, there's no age or health checks required also. Why so many people choose Avalon? We've been established now for over 25 years, and we're in the UK. We're regulated by the FPA, which is the Funeral Planning Authority, and abide by their set of rules and code of conduct. The money is held safely and securely in an independent trust fund held separate from Avalon. We offer coverage throughout the UK, Spain, Portugal, Cyprus, and the Canaries. And we've got a dedicated local funeral liaison team that are available 24 hours a day, 7 days a week, 365 days a year, and speak both fluent Spanish and English. We're also recognised. We've got a 5-star excellent rating on Trustpilot. We've just won our 3rd award as voted for Best Funeral Plan Provider for the UK Personal Finance Awards. We've got over 85,000 customers here, and somebody purchases one of our award-winning plans every 10 minutes. So I know that there's a lot of people here within the Costa Blanca region that have got Avalon funeral plans or are thinking about taking a funeral plan. What I'm going to quickly explain to you now is 2 unique benefits that we're able to offer you. So we've just introduced the Avalon Promise, which means that if you pass away before the plan is fully paid, then Avalon will cover the costs of the funerals, providing extra peace of mind. Obviously, this is available on plans that are taken on instalment basis over 2 years, but it covers all the costs of the services included in the plan, so your family don't have to worry about the costs. Obviously, as well, with COVID and the pandemic that we've had recently, we've introduced the Avalon COVID-19 guarantee. So our plans now offer extra reassurance should COVID-19 restrictions or any other natural disaster prevent some of the elements in the plans taking place. So where this happens, we'll support the loved ones in making alternative arrangements, and if necessary, we'll provide a refund for the features of the plans that can't be used. We are obviously very proud of the fact that we are the only funeral plan provider to be able to offer this, giving extra peace of mind to our clients as well. If anybody is thinking about funeral plans, then come and talk to us. I know it's not top of everybody's agenda, and we don't always want to face the conversations ahead. But we are able to offer consultations via phone, video conference, in the comfort of the customer's own home or in one of our office locations on mainland Spain also. Thank you.
Okay, that's very good. Actually, we have here some questions, Becky, as well. Well, basically, they're saying, do Spanish companies also offer basic funeral plans similar to Avalon and Golden Leaves? Well, to be honest, and we're dealing in our office, particularly with Mapfre, because we could only cover one in our office. And to be honest, I don't know what you guys think, but Avalon is being very, very competitive towards anything else. You know, it's been very good. I haven't found a Spanish insurance company similar, but I will suggest Alice to have a comparison and discuss it with Becky probably. But I know it covers Spanish insurance do not cover if you decide to move to the UK, and Becky, you do cover if they decide to go back to the UK and they don't just is that correct?
That's correct, yeah. So we get this question quite a lot because people you know, get confused between what insurance is and what a funeral plan is. So a funeral plan is not insurance. Insurance, we have many people that will maybe choose a life insurance policy or a funeral plan insurance policy. These policies can be maybe a fixed amount that you decide you want for your family to inherit after death, or it can be a funeral insurance that you have a fixed amount each month that comes out of your bank account that can last for life until death occurs. With a funeral plan, you're prepaying for the funeral in advance. It's a fixed cost. So whether you live for 20, 30, 40 years, you don't pay anymore. It's a fixed cost.
Okay, right. Basically, well, we could be talking forever here about a lot of things. You could see the panel. Pedro, for example, I've got another one about hológrafo. I know that's very Spanish one. Do you want to mention a little bit what is hológrafo, which I don't know, probably the English words will be just written down by yourself in case, obviously it's not the recommended will, because I think that could only bring problems in the future, can it? It could be a kind of worms. Well, I remember in the COVID, if you remember, Michael and Pedro, when we did these webinars on COVID, there was a lot of panic about, you know, organizing, if you're in hospital, organizing a will. I don't know if it happens to you as well, Michael, calling the notary, going there, you know, it's very stressful. So
yeah, it's a crazy system. It's just that our civil code was written in, I think it's 1800s or something like that.
1889, isn't it?
1889, yeah. When there happened to be a lot of pandemics around that sort of time. So there was actually an article that said that during a pandemic you could exceptionally do a will in a different way, which we've both done.
Which is better than nothing, isn't it, Michael? It's better than nothing.
So in other words, allowed to do a will with 2 witnesses. The thing is that the law also said that the moment the pandemic was officially over, you had to go and get it ratified by a notary. So at the end of the day, as sort of someone that's just about to die, it was a good last resort. We did 2 of them, but in reality, it's not the way to go. And holographic wills and all these other types of wills really shouldn't be used. We should all do a normal will in front of the Spanish notary. I don't know what Pedro has got to say about this.
No, absolutely. I fully agree. Obviously, there is this way we call it testamento hológrafo, or also this specific testament about pandemic. But obviously, we never recommend to do it in like handwriting when someone reaches legal age. And because it has the validity comes in some certain time, needs to be done correctly, even though it can be done, for example, by someone with their own language, for example, in English or any other language, but it should be done in a correct way. And then the validity, it's sometimes it needs to be brought into a notary also. So there could be situations that could be rejected, and that's would be a big problem for the testator and obviously the beneficiary. So always it's something that we never, unless there is an urgent situation, unless there is something that for some reason, for example, I don't know, Michael, I'm sure that you have also experience on people which in hospital. I'm sure that you have many experience, and people sometimes say, well, unless we brought Ignacio, the notary has gone to make a will. This is what we always recommend. Could we make by handwriting? Yes, but I will not recommend it, because it will be in a litigation. This could be a problem. You know?
Yeah. The problem I find, Pedro, the problem I find, Michael and Pedro here, and sorry to start the debate here, is that sometimes you don't make it. And the holographer, my only opinion here is that holographer is better than nothing unless the notary arrives. You know, because unfortunately, in some occasions, they don't arrive, and it's not that easy, unfortunately. And I did complain a little bit, but they could ring you from one hospital that the only one allowed is this public notary, and that public notary needs to go there. And I don't know, Michael, your experience, if they've been very quick, but I mean, unfortunately, in our case, I remember one. And but anyway, these are just exceptions, obviously.
Yeah, I'm not very brave, so I wouldn't dare recommend anything but a will and sign in front of a notary under any circumstance whatsoever.
Yeah,
I think it's the chance of it going wrong is extremely large, but extremely large. So I would not dare. I would not dare recommend. So if a client of ours did a will on their own, handwritten, because it was urgent, they've done it because they wanted to themselves. But I definitely wouldn't dare recommending it in any way.
No, I'm just saying that there is certain emergencies that might be the only option you have. That's probably the only option. But obviously, try, and the whole point is to do wills beforehand, ahead. You know, plan advance. Not just straightforward now running around when is it, you know, these things, obviously you end up having the stress and paying for it.
I mean, the thing is, really, every English person that buys a property in Spain, at the same time that they sign the purchase deed, they should sign a will. And in fact, nowadays, 99% do. I mean, we handle some intestate cases, and not very many, not as many as in the past. People now realize that it is very, very important.
Yeah, I agree. I mean, at the end of the day, I think most of the people, I will say 99% as well, have their own will. There is, unfortunately, you could see exceptions, and you see the difference, Michael, and you could see the difference. I don't know, Jan, would you like to add anything? Back in the UK, obviously it's a different system, but would you like to add anything here with all this discussion? Over to you.
Yeah, it's really interesting, isn't it? I mean, I think the practice with solicitors that are dealing with property purchases and sales, it is to recommend that a will be made at the same time, and also the divorce solicitors would do the same. But of course, it's a voluntary thing in that respect, and it's difficult to persuade people that they need to do it. So it's a bit of information giving from the lawyers as to what the outcome could possibly be. And I think the COVID pandemic has demonstrated to everybody that not only is it older people, but it can strike anywhere. And I think that also brings out the importance of considering living wills and treatment as well, because it very often doesn't deal with the sorts of things people think it deals with. I sort of was doing some training, a university course on dementia and living wills, excuse me, and I hadn't quite appreciated some of the niceties of do not resuscitate, and when you look into that, people sign the DNRs and they don't realise that actually they can still be fed and they can still be given medication. It's just that the defibrillator cannot be used on them to resuscitate them in that way. So there's a lot of things that people need information on and need to be careful about. And I think that this forward planning goes back to what we said right at the beginning: take the stress out of the situation, don't leave it to a crisis point until somebody is in hospital, and then it falls on the loved ones around to deal with. So yeah, it's just forward planning.
Thank you, Jan. Our friend Rob Innes, hello Rob, he just reminded us that we didn't even touch the fact of power of attorney, Michael and Pedro, endurable power of attorney. What would you like to add, Michael, your experience with endurable power of attorney? Over to you.
Okay, well, Jan's just brought something up. She mentioned dementia. And one of the things that we've been helping the association here to Alzheimer's things. And one of the things that someone that is diagnosed with Alzheimer's in Spain, they're just at the beginning, they still know what they're doing, but they know that it could be 20 years, hopefully, but it could be sooner. We always say that as soon as you're diagnosed, you're really going to need to see your solicitor to do a bit of planning, and then you can forget about it for a long time, but you need to really do the planning. And we always recommend people that have been diagnosed with Alzheimer's to do the following. The first thing is to really think about granting a power of attorney to your spouse or to your kids. And I say this because in Spain, unlike in the UK, where you can go through, get a power of attorney once you've already lost your consent, and quite easily through the family courts, in Spain, it's a disaster. I mean, Spain's a year and a half to be able to get the judge to let somebody else sign for you. So what we see sometimes is, a couple, one of them, the lady's got Alzheimer's. Now she goes into a home. The husband wants to sell the property because they need the money. Now he can't sell it. It's half in her name, and we're trapped. So one is the moment one is done, sign a power of attorney. Think about it carefully. Grant it to a couple of people so they jointly have to sign if you don't trust your husband 100% because it's a second husband or third husband. But there's ways of doing that. And the second thing is, have a look at your will very carefully, because it may be your last chance to change it. So have a look to see where you are, because you may have done one 15 years ago. Think, is everyone still behaving well, not behaving well? That's the chance to change your will. And the third thing is a bit more painful, but if your spouse, for example, has left everything to you, and there's a second thing, it's down to the children, think about your husband changing that and not naming you the beneficiary, because you may have really serious Alzheimer's when it's time to inherit, and then that property or those assets are going to be trapped. So we always say, look at those, the power of attorney, the will, if you're diagnosed with Alzheimer's. The other thing is when we have a couple that's sort of, in their 50s, 60s, maybe even 70s, we don't normally talk about sort of necessity of them doing powers of attorney if they're healthy, because it has some risk obviously involved. But if a couple come to us, they've been with each other for 40 years, 50 years, and now they're both 80, getting on, and they talk about wills, we always tell them, we do the wills, but do a reciprocal power of attorney as well. So that if one is a bit ill or something, the other can still maneuver. And that's where the sort of the cost reward starts being worthwhile, because there's less chance of the other running away with their money or there being a very serious change of circumstance. It's an important document as well.
I'm not sure if Pedro just raised a hand. Pedro, would you like to add anything else there?
Well, it's a good point that has been said by Rob, and I fully agree with Michael. Obviously, I would say we've been always recommending these kind of powers of notary powers, that could be focused on individually in order to manage with individual things, and also for patrimonial issues. on assets, when someone may become in a situation where it cannot decide what to do personally and also for the assets. So it's extremely important to choose someone, and when he's going to be able, that faculties in order to manage with the asset, manage with the decisions that need to be taken into individually with a power of attorney, will eliminate other problems in the future. I fully agree with to choose also the children in order to do that. But that is something that we already recommend in our website. There are plenty of information about this. It's something that when you are from, I would say, but also for Spanish, but when you are a national and you come here and there's no family here, it's something that is extremely important to do.
Mm-hmm. Right, Stuart, would you like to add anything here? I mean, so many questions, so many things. I'm sure you've got something to say here.
No, I think it's been very enlightening to actually, we never think about this. You know, it's something that even I moved to Spain a few years ago from my personal perspective. You don't think of writing a will straight away. You don't think of all the issues that come, but obviously everybody thinks they're going to remain young, that this day never happens. And in a lot of cultures, we don't talk about death and planning as well. So I think even though I'm in my, I'm 40, it's highlighted the essential kind of need to have those wills. Even though I have a British will, my action point from today is to give you a call, Ignacio, and have it sorted out. But I think also that if you are divorcing or separating and you've got your ex-partners in a different country, these are things that really are important to consider. And people having new lives, it's very important to sit down and make sure that when the day happens, you do leave it to the right people. Yeah.
Okay. Yeah, Michael.
I think there are so many good questions actually. I'm seeing up the chat here. So
I know. Which one? Pick the one.
Well, look, I mean, there's one here as well. Can we also choose to apply national law for Spanish assets if we're from the US?
I know.
Now, this is very good. Another very good question, because that mistake we've seen a lot. People don't realize the US is like, say, in the United Kingdom. In the US, there are very different rules.
Yeah, so you need to mention, correct.
What we've noticed is that if you choose your US law and you specify that you're from Delaware or from the New York, whatever, when you go to probate, the notary will just accept it. He won't ask for any more proof. Now, if you don't mention that, he will ask for the tremendous amount of proof regarding, if you were born there, how long did you live there, etc. So if you can't just say, I choose my US law to determine how I can distribute my Spanish estate. No, you can't do that. You've got to actually say what law that is, and nobody will ask any further questions. If you do, you'll have to prove what that law is, because all Spanish notaries know what the English law says. Not all Spanish notaries know what the law in New York is regarding obligatories. So they will ask for a certificate of law from that country before they apply it, but they won't question your choice of New York law if it's written into the will.
It's good you mentioned, because every time we sign them with Americans, that's exactly what you said. You need to specify what state was the country where they leave before they came to Spain. So it's specific, obviously, on every individual state.
The next one's good as well, about the life insurance policy.
Which one is the one?
Life insurance benefits are taxed in Spain, are they? What happens? Okay, so life insurance policies are just, as far as they're not added to the probate deed, but when you do the inheritance tax declaration, if you're a resident in Spain, it doesn't matter whether the insurance policy comes from the States or any other country like this, you have to add it to the value of the estate, and then you apply the corresponding exemptions. Let's say in Andalusia, €1 million free, and after that 99%. In Valencia, you've got high exemptions as well. But it is, if you like, in principle, added to the estate as far as values. It doesn't mean it's going to be taxable, because that will depend on the exemptions. But it is just considered part of the rest of the assets. Yeah.
Right. Okay. Jan, is there anything we're missing here that you would like to add?
No, I think it's been wonderful.
I think we should have covered 2 hours webinar.
Yeah, 2 hours.
2 hours, 2 days. I think this conversation could go on for a long, long time.
Yeah, that's good. That's good. Right. I think we're running out of time. Pedro, Michael, any
Okay, I think
you've gone very still there, Ignacio.
Okay, we can see you now, Ignacio.
Sorry?
We can see you now.
Okay, sorry, I was frozen probably, yeah? No problem. Is there anything else you guys want to add here? Because I think it's been quite productive. I know there is, what I recommend you to do, if you're okay, could you please put your email in and the website for all of you, for people, And I think we're going to say it loud as well, because some of the recorded version will not even say. If you want to say your website, Michael,
yeah. Okay. So our firm is Davies Abogados. daviessolicitors.com. We're based in Andalusia, and we deal with inheritance cases all over Spain. We also deal with wills, but the wills we only deal with here in Andalusia. We're based in Marbella, Almeria, and Majaca.
Okay. Pedro, would you like to just say where they can contact you?
I have included my email on the website. Obviously, there are some questions that I would have liked to answer about. Of course, without time, as I can see the double taxation treaty, which I would like to answer. But I invite John to contact us, and we will have a brief chat in order to explain what we think about the situation, about what would be the residency, for tax residency for him. And obviously, where we deal obviously with immigration, with property, with with taxes, international taxes, and international litigation. Obviously, one of the main fields also is about also inheritance and family matters. And obviously, there is my email, and I invite everyone who would like to contact us. Please go ahead. Okay.
Jan, did you mention here just in case clients from the UK, did you mention here your email and
yeah,
you could say your...
I've put my email in there, which is the best way to contact me. And I deal with any sort of conflict situation within the family, also as an elder mediator coordinating future plans, living wills, future care, any of that sort of aspect, I can mediate or coordinate. So it would be lovely to hear from folks if they wanted to chat about that further, and I can send some information about mediation in general for those types of discussions. Thank you.
Thank you. Stuart, anything else about how they can contact you, because you're here in Costa Blanca?
Yes, if you're going through a divorce or separation, or have child arrangements issues, or are preparing a financial order, then it's best to contact me through Ignacio or Pedro, and we can then liaise with yourselves to sort things out with regards to agreements going forward. Okay.
Okay.
So thank you.
Okay. Thank you. Becky, anything? How can they find you?
Yep. So email's best. I've dropped that into the chat there. And they can also visit our website as well. But please feel free, if you've got any questions, just to drop me a mail, and I can send some information and get back to everybody.
Okay, well, thank you very much to all of you for your time. Actually, we're going to just leave it for this year now. I think we've been doing a lot of webinars. We will carry on doing in January. Probably about buying a property in Spain, even finances, what the things to choose, or what the things to know before you commit yourself into an investment. That will be part in January, but we will just publish it on board in the future. So have you all Merry Christmas, Happy New Year to all of you as well, if I don't see you. And I'm going to pass it over to Juan Fran and say goodbye for now. Okay, so thank you very much for your time. Over to Juan Fran. Thank you.
When a loved one passes, it takes time to assimilate losing them. At these times, when you least want to deal with paperwork, Pellicer and Heredia are here to help. One of our lawyers will be in touch to inform you about the process and answer all your doubts on the legalities. No matter where the assets and heirs of the deceased are located, and without having to travel to Spain, we can advise you and carry out all the required proceedings in Spain. Obtain the death certificate, search for assets, debts, and existing insurance policies, give advice on accepting or renouncing the inheritance in Spain, hand over information on all the related costs, pay all the compulsory taxes on your behalf, and translate all the legal documents required. And remember that upon death, when carrying out all these processes, legal deadlines apply. Through this difficult time, when you most need help, Pellicer and Heredia is with you every step of the way. Pellicer and Heredia, international lawyers.